The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have 3 cases that will be submitted this morning. Those cases are AFSCME Iowa Counsel 61 and others versus State of Iowa and the Iowa Public Employment Relations Board. Second case is Iowa State Education Association and Davenport Education Association versus State of Iowa and others. And the final case is Iowa Supreme Court Attorney Disciplinary Board versus Benjamin Stansberry. The last case is now submitted to the court without oral argument, and we'll proceed to hear the arguments in the AFSCME case. Mr. Hedberg.
May it please the court, I'm here today with my associate, Sarah Baumgarten, representing AFSCME Iowa Counsel 61, a labor organization representing public employees throughout the state of Iowa, both employed by the state of Iowa, municipalities, counties, and other public entities. I'm also here today representing individuals. They are Ryan DeVries, a university police officer, campus police, Jonathan Good, a corrections officer with the state of Iowa, Tara Kinney, a motor vehicle enforcement officer for the state of Iowa, and Susan Baker, a drafter for the state of Iowa. All these individuals have been adversely affected by House File 291, which has taken away their collective bargaining rights and desperately affected their ability to bargain for terms and conditions of employment, either in the state of Iowa. We're challenging the House File 291 basically under the Iowa constitutional guarantee that all laws shall have a uniform operation and the General Assembly shall not grant to any citizen or class of citizens privileges or immunities upon the same terms and shall not equally belong to all citizens. We believe that in this case, by defining public safety employees and excluding identical individuals, and by the 30% threshold, the statute is both over-inclusive and under-exclusive and does not serve any legitimate legislative purpose. For example, in the definition of a public safety employee, campus police are excluded. They do the identical work of any other police force in the state of Iowa, yet they're excluded from coverage under the public safety definition. Another individual...
Are campus police armed?
Yes, you are.
Okay.
And they're certified, they arrest, crowd control, they do everything a police officer would do in Des Moines, Iowa. They are excluded, though, because they're carved out. And the other group, airport firefighters, are carved out, yet they have the same duties as any other firefighter in the state of Iowa. They can be called upon, actually, not just at the airport, but other jurisdictions, yet they don't have those abilities. So they are excluded by the definition without any legitimate reason. And included are individuals that really have no public safety function. For example, the fire inspector, they inspect, they do not fight fires. The other individual, the river gaming enforcement officers, they don't arrest, they just check out the slot machines. So they're included, we're excluded. Another problem we have with this statute is, and if you look at the numbers, that's a significant group of folks too.
Let's talk about the numbers a little bit if I can. And I'm interested in talking about excluded AFSCME public safety officers.
Okay.
And from reading the materials, I gather that the statute has been drafted so that no AFSCME public safety officers have the full. I take it that's a correct fact. But I'd like to press you a little further on it though. How many AFSCME public safety employees have been excluded, and how hard was it to come up with a system that excluded them 100%? I mean, I don't have a solid sense of the proportion.
Well, I don't have the exact numbers in front of me, but it'd be hundreds. You know, there are a number of, and this is not just This is Iowa City, this is Ames, and you and I, you know. So we're talking about a significant number of individuals who are not being allowed to collectively bargain. And it's not just through the definition that affects these folks, it's the 30% rule as well, because that goes in and affects not only AFSCME folks, but a lot of other folks out there who have those same duties, but they're excluded. We have a list of them in our brief. For example,
Let me ask you this, you know, in a somewhat analogous context, maybe a reapportionment context, there's some recent case law floating around the federal courts talking about some reapportionment statutes that surgically excluded African Americans. And they looked at the pattern and said, oh my golly, look how unusual it is. Is there a case that the AFSCME employees were surgically excluded? And I guess what I'm looking for is how unlikely is it that you'd come up with a statute that was 100% effective in excluding
right, and
AFSCME
the
employees?
impact on our associational rights is exactly the second point of our brief and argument, and that is that we don't have a right to bargain. But when the state's granting out a privilege, it can't do so based upon the association that the person has with the various groups. And in this case, we believe they gerrymandered the statute relative to...
Okay, fine, but I'm probing, I'm trying to figure out, how difficult was it to come up with this arrangement? I mean, did they move around parts? Did they have a computer program to generate it?
Well,
I have no idea.
No, you would go to the collective bargaining agreement, and you would look at the bargaining unit, and you'd find out who's in it and who's out of it. And there's job descriptions, and that's how you would do it. Those are published. That's a public record. And by the way, you'll see the public record would also reflect SPOC, that's the State Police Officers Council. They have a bargaining unit with their employees in it, and they're included. All theirs are included. AFSCME's are excluded. It's an interesting phenomenon as well.
But following up on the Justice Apple's question, are the voting rights cases governed by a different standard of review? Is that higher than a rational basis test?
Yes,
Okay.
yes, Your Honor. It's a stricter.
All right.
When we're talking about First Amendment, freedom of association, it's a higher standard and burden for them. And the numbers don't really matter either. An individual whose rights are affected is just as bad as if it's 100, you know, in terms of the Constitution, we believe.
Mr. Hedberg, do you know in other states, does AFSCME represent state police, or do they represent local law enforcement?
Yes. I believe you got to understand other states are framed differently than Iowa in terms of how their public safety systems are set up. I do know we have corrections officers throughout the United States. I do know we have police officers in Iowa that we represent, not just AFSCME state of Iowa employees. But I don't practice law in Missouri, I don't practice law, and they all have different bargaining rights and different obligations, so I can't answer that with any degree of certainty. I can just say, generally speaking, we have represented law enforcement in other jurisdictions throughout the state.
You filed a notice of additional authorities recently citing the Janus case. How does that help our analysis?
Well, I think what Janus points to is the First Amendment and the freedom of association aspect to collective bargaining can be affected. And again, that's the second prong of our argument, namely, but we feel that the strongest part of our argument is just the over-inclusiveness and under-inclusiveness that the statutes wreaked havoc on the purported purpose of enacting in the first place, and that is you have this 30% threshold to meet. And so you have Tama County, you have Sheriff's there, you have Delaware County, Harrison County, all these population centers that, because they're in a bargaining unit that's mixed, they have zero rights to bargain over these items that other people do have.
Does the rational basis test require a perfect fit?
No, but not so far off or far out that there's no fit at all. It's almost a random. And if you look at it, for example, in Woodbury County, you are excluding certain, excuse me, like Blackhawk County, 133,000 people are disfavored just because they're not 30% or more, but it's 100% of the public safety that's excluded. So that purpose of either providing benefits to avoid strikes or whatnot, which we don't agree with anyway, we don't believe that's a basis, but that's not being served by denying that whole population of deputies or police officers the right to bargain over that.
Is there a different percentage that would pass constitutional muster other than the 30% threshold?
I think a 30%, 10%, whatever, doesn't. It's random. It doesn't take into account the legislative purpose, which is to provide enhanced benefits for certain public employees because of either we want to have them bargain over public safety issues because they're involved in health and welfare, health issues, or conversely, the fear that they will strike. It just doesn't serve that purpose.
I'll ask you about a case in the 90s and see if I can get your views on how your rational basis with fight test would apply. It's called Kelly versus State. It's 1994. And there we had a statute, a state statute, which gave union employees a 10% raise and everybody else a 7% raise. And the court, I will just tell you, I mean, it was a cursory opinion, but basically said, well, that's okay, because we apply a rational basis test. Well, if we apply a rational basis test with bite, as you're suggesting, it strikes me that Kelly case may well be invalid. Help me out.
As I recall, the Kelly case, in my mind, they weren't in a bargaining unit. They hadn't formed one. It wasn't a denial of the bargaining unit's raise, or union raise. It was individuals that were not in a bargaining unit.
They got a lesser raise than those
Right,
that were.
and we're talking about the different judicial districts, correct? Right.
Yeah.
And so that judicial district didn't have a bargaining unit to collectively bargain in the first place, as I recall. Now, that was a big distinction.
But it seems to me a little odd that union members who have the collective bargaining got a statutorily mandated 10% raise, while those that weren't organized got 7%.
That's why you organize. Is get together as a group, certify yourself through the state of Iowa, and then be able to bargain over these things as opposed to willy-nilly individuals. I would imagine it may seem more unfair. Individuals within that judicial district could have gotten one person over there a 10% raise, one a 5%, 6%, 7%. So I don't think it's an perfect analogy either on that case, as I recall it.
How about this attenuation question? I mean, we're having some debate here. I think you agree, and the cases generally tend to state you don't need to have mathematical precision. And I think that's widely held view. Legislation can't be 100% perfect. On the other hand, the case law, going back for some time, suggests that, well, if it's over-inclusive and under-inclusive, but where do we draw the line? I mean, at some point, obviously, we say it's too much, and we kind of go, ugh. But help me.
I think this is one of those cases that gags you. It's so over-inclusive and under-inclusive that we don't really have to dabble with the number given to us is 30%. I don't think it's up to me to tell you folks what number would be good or bad. I'm just saying that number, when you apply the facts at hand and the different bargaining units we have, is grossly under-inclusive and grossly over-inclusive, just on the sheer facts of the case. So I'm not asking to fine line here. I'm just saying this 30% is obviously grossly over and under-inclusive based on the fact that
Why isn't a concern that police officers might strike and the resulting impact on public safety, why isn't that a legitimate reason to treat them differently?
Well, we don't accept that because, first of all, Iowa's never had a strike for police officers. Two, there's all kinds of negative things. There's enough sticks in that to keep them from striking to begin with. Well, you can go to jail, you get fined, decertified, lose your ILEA status, which means you can't be a cop anywhere. And so adding this to it doesn't add anything to it. And if you, interestingly enough, those jurisdictions where there are great rights of collective bargaining, New York, Chicago, they strike there. So it's not inoculating anyone to the blue flu by giving them these benefits to bargain. And second of all, the right to bargain doesn't mean the right to get it. You go to an arbitrator, he may not give you the raise, or she may not give you the raise. that doesn't, you still can't strike.
The Wisconsin experience relevant here?
No. First of all, I don't know what the penalties weren't as severe as they are here. Secondly, our statute is different. There's carved out public safety, and so within a wall-to-wall unit, you could still bargain for these benefits that you can't bargain for in a non-public safety employee. So there's a big distinction there in terms of why that passed muster and why ours doesn't.
Let me ask a practical question. Could the legislature have come up with a statute that said, okay, public safety employees, we like you. We want to encourage retention of public safety employees in state government generally. And as to public safety employees in any bargaining unit, we say, with respect to them, they have full collective bargaining rights. Could that have happened?
Happens all the time. In the wall-to-wall units, prior to enactment of this, there are different issues that a cop in a city would have that are different than the person that is cleaning the floor. Happens all the time, and there's no reason why it couldn't happen. And even within the public safety, for example, Des Moines Police Bargaining Unit, we have different sub people in there getting like bomb dogs, meth labs, enhanced and supplemental pay, or different schedules. So no, you're completely right. As a practical matter, it doesn't cost anything to do that.
Thank you, Mr. Hedberg.
Thank you.
Mr. McDermott.
May it please the court, counsel. I'm Matt McDermott. I represent the defendants in this action this morning. The amendments to Chapter 20, which were enacted almost 2 years ago now, are a legitimate public policy decision by our legislature. The state reformed our collective bargaining system in a way that conceivably and rationally gave state and local governments more flexibility to control their budgets and balance the state's legitimate interest in preserving public safety.
Well, let me ask you about the AFSCME question that I asked your colleague. So all the AFSCME public safety employees are excluded. It just strikes me, just with that fact and knowing no other facts, it kind of curls my eyebrow a little bit. I say, how'd that happen? I mean, there are AFSCME employees all over the state, and there's quite a few of them and so forth. How did it happen that at the end of the day we look at this and with 100% effectiveness, all AFSCME employees are excluded? Can you explain to me what's in the record that would explain that process?
I don't believe anything in this record that would explain that. The legislative record is very limited here. I think that it requires an overall analysis of what
Doesn't it strike you as a little odd? I mean, here's the statewide, and we got employees scattered all over the place. We're talking about thousands of employees, and every last one of them is excluded. I mean, it just seems a little odd to me, and I invite you to respond.
There's nothing about this statute facially that would exclude AFSCME members, and in fact, if AFSCME had units that included more than 30% PSEs, then the AFSCME unit would be recognized with the enhanced bargaining.
Let me ask you this, and it's an inference. I'll start right out, but I mean, the armed people at the University of Iowa are excluded. Why are they excluded? Is it because they're AFSCME or because there's some kind of difference? And one kind of wonders whether, I mean, basically what the statute does is there's probably, 25 classifications of public safety officers, and some are favored and some aren't. And how did they come up with those classifications? It seems like the unifying principle is that there's no AFSCME people. But help me.
Yeah, I think that what the legislature was trying to do here, at least what we could rationally and conceivably find, is that they were trying to limit the number of people that would be subject to these enhanced bargaining rights, while at the same time trying to make sure that there was a minimum number or some critical mass of PSEs that would be available to ensure peace if something happened. I think that with respect to campus police, a legislator rationally could have determined that other PSEs could have maintained peace and public safety even without the campus police. And so in that respect, they would be redundant. Additionally, campus police answer to a different authority. Campus police are subject to the Board of Regents and to the university presidents. And so it is at least rational that a legislator could have said that campus police need not be part of this group.
How about I'm going to repeat some of the questions I did on the other side because I want to give you an opportunity to respond, but this business of over-inclusive and under-inclusive has been explored to some extent. And obviously, in some bargaining units where there's 69%, outside the scope of it, they get the benefit of it, so it's over-inclusive. And then, on the other hand, we have all these correctional officers, and they're not, it's under-inclusive, over-inclusive. It seems to me the law is clear that it doesn't have to be perfect, and I think we all accept that. On the other hand, the law is pretty clear that over-inclusive and under-inclusiveness is at least a consideration or criteria to be considered. And I think maybe all of us agree with that.
Yes, Your Honor.
But the question, of course, is where do you draw the line? Help me.
Yes.
And help me there, please.
I think it comes back to what is essentially the three-part test that Racy established. And the third part of that test is the classification or the connection between the classification made and the goal that the legislature was going for. And in this case, we would say those kind of twin goals. Is it so weak that it's arbitrary? And I think that a legislator here rationally could have determined that 30% threshold is rationally enough to get sufficient PSEs in bargaining units that would have those enhanced bargaining rights, that they wouldn't strike or have some sort of similar blue flu or labor unrest.
Here's a question I have for you, Mr. McDermott. You would agree under the rational basis test that there has to be some independent basis out there for the distinction. The legislature can't just draw a line because it's politically easy to draw a line in a particular place.
Correct.
When I hear this civil unrest sort of, kind of justification, I know that's not really an accurate term for it, but for better or worse, doesn't that somewhat come close to this idea of what's politically possible and what would be politically different as far as a justification for the line drawing that the legislature did?
I mean, I think as a general matter, we have to, and in this instance, our legislature wasn't writing from a blank slate. In Wisconsin, when a similar statute was enacted, they had labor unrest there. They had sick-outs that occurred, but those sick-outs did not occur with PSEs. And so I think our legislature could have rationally looked at what happened in its neighboring state and seen what had happened there and determined that there was a risk of labor unrest that could have led to people not showing up for their jobs, which then...
Could the legislature pass a tax law and say we're going to exclude tax protesters from the tax law because they'll make our life difficult?
No.
All right, so how is this different?
This is different because there's nothing about this statute on its face at all that directly targets AFSCME. And in fact, so long as the unit has more than 30% PSEs, AFSCME units would be recognized with those enhanced bargaining rights.
It seems like they picked the 30% to exclude AFSCME somehow, because the old saying is even a blind hog gets an acorn once in a while, and AFSCME didn't get any acorns in this thing.
Again, I think it comes back to the three-part test, and under that test, the legislature has a wide berth in determining what the line should be.
But the second factor sort of bothers me. How do you say that the state's claimed interest has a reason in fact in the state of Iowa? I mean, we could look all over the country what happens, but how does it have a reasonable basis in fact within the state of Iowa?
I think that our legislature rationally can look at what happens elsewhere to try to make sure that those harmful things don't happen here. For instance, we've never had a terrorist attack in Iowa. We've never had an Ebola virus outbreak in Iowa. It is still rational for our legislature, having seen those things happen elsewhere, to try to put measures in place.
And our law has been strict enough. We've never had a walkout, a slowdown, a strike, because some of the things Mr. Hedberg talked about, you know, you strike, you're going to be decertified. You have all these other things, and I don't know if Wisconsin has those things.
Wisconsin's statutes are not as stringent in terms of the penalties as what Iowa has, but as we all know, simply outlawing something doesn't mean that people aren't going to still do it. And one might argue that the sorts of things that might be just as bad that don't rise to the level of a strike, like a blue flu or some sort of other sick out, are just as harmful, and that the legislature rationally here could have deemed necessary to try to avoid.
You say could have deemed, but it has to be reasonably conceivable in fact. And could have is not the test under RACI.
The fact that our neighboring state had these very issues happen when a similar statute was passed, I think makes it conceivable in a reasonable and rational way that it could still happen here. The citizens of Iowa are not that different from the citizens of our neighboring state. And so I think that for our legislators to look to that, to try to avoid the same problems that happen there, is a rational thing.
Of course, that's not what's in the record. At least the debates that we had on this, it was all focused on the benefits that were going to be offered, and that the police and fire folks that were covered had substantial risk, and you know what it says.
Yes.
And there were, I mean, I don't know how many, there were quite a few people participating in the debate. No one suggested the rationale that you're now advancing. Shouldn't we hold the legislature to what it says and what you know, I mean, we look at the purpose of legislation all the time and do what we can on it. And here, the purpose of legislation looks like providing a benefit to a certain group of people.
But we look at that in a different context when we're looking to what does a statute mean. The cases are very clear, going back to Chief Justice Marshall in 1810, saying that we do not look to the motives of the legislature in invalidating a statute.
Sure, but we look at what they said. I mean, I understand the distinction between kind of psychological motive. There's 150 legislators, and there's no one psychological motive likely. And so I accept your notion of what does it mean. But nonetheless, the character of the debate in the legislative history is a useful tool in determining what the statute means. And if this was an anti-strike provision, isn't it a little extraordinary that nobody mentioned it in the legislative debate, as far as I know, and correct me if I'm wrong, because I might be, but.
There's nothing in the record about that. But under the rational basis test, we don't have to look at what the legislature actually said. We only have to look at what they conceivably had in mind. And remember, very few people that voted in favor of this bill are actually on the legislative record. So there are certainly many others that we don't know what motivation they had, what their interest was in voting for it.
Let me ask you this question, and I think it's clear, but if the purpose of the statute was to exclude AFSCME members, I mean, and I will tell you, I didn't see that anywhere, but if that were the purpose, that would be an invalid purpose, would it not?
It would be an invalid purpose, but under the rational basis test, so long as there is a rational basis for the classification, we do not look to other motivations that might include animus. And of course here there's nothing in this record on that point at all.
Why treat prison guards differently? Why not include them in the public safety definition in that group, given the risks they face?
Prison, and again, the legislature has a very wide berth in terms of what's in and what's out. And so in deciding what is necessary for this critical mass of public safety personnel, it is up to the legislature to kind of make that call with respect to the employees that you're talking about, they are not peace officers. They don't make arrests, and so I think a legislator rationally could have determined that they were not among the people that were necessary to exclude from the general group that was not getting the enhanced benefits.
What would happen if you had a strike of correctional employees, I wonder?
Well, certainly it might be a problem, but it's up to the legislature to make the call as to how big of a problem that is, whether there are others that can take over those jobs, things of that sort.
Has our court ever applied the RACI test to strike down a legislative classification?
To my knowledge, it has not.
Except before then, we did beer camp, we
In
had
beer camp, it did, correct. In
Grabowski maybe, I mean, that's the Civil War veterans case, one of my favorites, the 1900 case where Civil War veterans didn't have to get peddler's license. We struck that down.
beer camp, I think, was sort of the first that I can think of. I do not recall any since 2004.
Beer camp was the guest statute. Right.
Correct. That treated passengers in cars differently based upon where they were from.
Chicago, the railroad case where we said something to the effect that there was a wage payment penalty, a criminal statute that said if you worked for the railroad and you didn't get paid, it was a crime, but not for everybody else. And we said, oh no, that was over-inclusive and under-inclusive, and we made short work of that one too.
In the time that I have
We
left,
also made short work of RACI. We struck down the gambling tax in RACI.
Correct. We have a system of government in Iowa that works, and it is a separation of powers. And we believe that the statute that was enacted here is certainly one that meets the rational basis test, and for that reason, we ask that this court affirm the district court. Thank you.
Mr. McDermott, thank you as well. Mr. Hedberg, you may present your rebuttal argument.
In answer to the question of why correction officers are not covered, that's because they're represented by AFSCME. That's really the only distinction. They have the same risks to their self and to their health as any other PSE defined by the state of Iowa.
Let me ask you a question, Mr. Hedberg. It's my understanding, correct me if I'm wrong, that professional employees in the state of Iowa generally are eligible to participate in Chapter 20 in collective bargaining. Is that correct?
Correct.
But not if they work for the judicial branch, right?
Correct.
Is that unconstitutional?
That's a different dichotomy because it's a whole different set of folks. I don't see that the same as carving it
I'm
up.
interested in your views on that.
I guess maybe we'll be asking that question someday, and hopefully we'll get the right answer. But in answer to that question, I think there are a lot more distinctions than there are here in terms of the PSE. And getting back to this case, and in its particular, the gross over and under inclusiveness, and this argument of critical mass in the event of some civil outbreak. If you look at it, you look at Tama County, population 17,000. You look at Fayette County, population of 20. Delaware County, 17,000. Harrison County, Blackhawk County, $133,000. They do not have, they are in a disfavored bargaining unit because they don't meet the 30% rule. But that doesn't mean if they struck 100% of that means 100% of the people that are in charge of public safety would strike based on the theory that everyone fears a strike if you don't have these rich collective bargaining rights. That's disproportionate to any alleged concern about striking. It's just the way they parse that out. Take a look at the city of Cedar Rapids, population 131,000. City of Ames, 66,000. West Des Moines, 64,000. They don't have bargaining rights because they don't comprise 30% or more public safety people in that group. But yet, if they were to go on strike, it would be 100% of the public safety group going out. So it just doesn't make sense to me. It's illogical and irrational to have this 30% rule. It just doesn't serve that purpose.
Counsel, could you address the argument that the legislature could reasonably be concerned with avoiding the so-called blue flu or sick outs or work slowdowns? Officers could choose to be less proactive in doing their jobs, and is that a concern?
If it were, then why would you exclude large entities like Cedar Rapids, Waterloo? I mean, they don't have these bargaining rights, so they're under-inclusive and over-inclusive. That's what I'm trying to get at here, is if that's your concern about the blue flu, and assuming without conceding it would happen, this does not solve that problem in a whole grossly under-inclusive group.
Is it possible, as a practical matter, for an existing bargaining unit to say split up so that some group, the PSAs within that group, PSEs, excuse me, within that group could achieve the 30%?
There is a process, but it's extremely difficult and would leave them open without a contract for a period of time as well. It's a possibility, but it's very, very difficult to do. I've not been involved in one yet where it was done, and I represent public employees for the last several years, anyway. But again, I think this over and under inclusiveness, it just reeks. It just reeks of not serving that legitimate purpose, which is to prevent strikes, prevent blue flu, to give benefits for these people that risk their self for health and safety, because it doesn't include a large portion of those people in these various entities that I've just described. Again, we believe that the link between the purpose and the classification is so weak as to render the classification arbitrary. And that's what we believe that this does through the 30%, and also the definition, excluding public safety people, campus police in particular, from the definition itself. I have nothing further at this time. Thank you.
Mr. Hedberg, thank you as well. Ms. McDermott, thank you again. The case of AFSCME, Iowa Counsel 61 versus State of Iowa is now then submitted, and we'll next hear the arguments in Iowa State Education Association. We'll take a brief break to make a transition, but we'll remain on the bench.